All right, the Red Hot Breakfast here on Hot 87.7. The heat is on. Time for us to get into this special interview. First of all, President Hakainde Hichilema recently swore in a 25-person technical committee on the drafting of the Constitution. Now, a number of stakeholders have reacted to this development, including the Oasis Forum, who issued a statement on Friday, raising serious concerns over the manner in which the committee was constituted. This morning, we'd like to hear from respected constitutional and human rights lawyer Linda Kasonde. Miss Kasonde is joining us via phone. Linda, good morning and welcome to the Red Hot Breakfast. Just trying to get her on. Good morning, Linda. Welcome to the show. Just trying to connect with Miss Linda Kasonde. Let's try and get her on the phone. Hello, good morning.
Hello, good morning.
Oh, can finally hear you.
Good morning to all the listeners out there.
Good morning. Glad you could speak to us this morning.
It's an absolute pleasure.
Wonderful. First of all, the Technical Committee on drafting the next Republican Constitution was recently sworn in. What is your immediate reaction to this development?
Well, firstly, it makes me wonder why the government is so intent on trying to review the Constitution so close to the next general election. If you recall, when Munir Zulu and others went to court to challenge Bill 7, the court determined that Bill 7 was a nullity, i.e. the whole process was flawed from the beginning because of a lack of consultation. And if indeed this technical committee is being tasked to come up with constitutional amendments before the 2026 general elections, it is doomed to have the same fate as Bill 7 because of the lack of consultation. And let me just say that the previous technical committee of 2011 took 2 years to go around the country getting submissions from Zambians at district, provincial, and national level. And that is the standard that the Constitutional Court said that we must adhere to in making substantial constitutional reforms. So if indeed this technical committee is being expected to do all that consultation in the few months before the general election, then it's probably doomed to fail because it won't be able to do that sufficient consultation.
Okay. Let's talk about the legality or lack thereof with regard to the manner in which this technical committee was constituted. So it's a creation of Article 92.2F and 92.2J. Some people have argued that such a committee should have been set up via the Inquiries Act using Article 79. What's your stance on this?
So, I think what needs to be made clear is because this technical committee has been set up under Articles 92.2F and 92.2J. 92.2F gives the president the powers to appoint. It's a general provision. 92.2J says that all functions and powers of the president must be subject to a constitutional or a statutory law that prescribes how those functions are going to be executed. Now, the problem with this current process is that there is no constitutional or statute that backs how this technical committee is being set up and appointed. You see? So the problem is one of legality in the sense that, and you see this in the current discourse in the U.S., where President Trump has been issuing a number of executive orders or decrees on certain things, saying how things should be done without consulting their parliament. And the same thing is applicable here. The president does not have the power to issue directives without legal support. And in this case, there is no legal framework to support the appointment of this technical committee. Now, in the past, Constitutional review commissions have been supported by the Inquiries Act, setting out how the commission has the power to go around the country and accept submissions from the public. And it is not my position that the Inquiries Act is the best way to do it, but it's the only law we currently have. What civil society has been calling for consistently since the last 2011 push for constitutional reform is a legal framework that protects the process and the content of constitutional reform. A statute that will do that and protect the process from constitutional manipulation by the executive. And that has been consistently lacking every time we do constitutional reform. So that is the real problem that we have here.
Okay. Now, the committee is led by retired Justice Mshabati. But what do you make of its overall composition?
So I won't really comment on the competence of those who have been appointed. Definitely there's some credible people on the list. But I think the main question for me is this actually a technical committee? Because there's a distinction between a commission, a constitutional review commission, and a technical committee. So a constitutional review commission is a commission set up to consult people around the country on what constitutional reform they want to see. Okay? And remember, the Constitutional Court said that the golden standard is for the wide consultation to take place across the country at district, provincial, and national level, because that has been the previous standard, and that is what the court supported. Now, a technical committee is made up of experts, technical experts, who have expertise in constitutional law and in drafting constitutions. And it presumes that there's already been that consultation by a commission as to what people want to see in their constitution. And the job of the technical committee is simply to draft so expertly that there's no ambiguity and to ensure that the meaning that the people wanted in their constitution is drafted clearly. So that's the distinction between a technical committee and a commission. Now, it appears, according to the statement issued by State House as to what this technical committee is that in fact it is a commission by another name, because their role is to consult the people of Zambia as to what amendments they want to see. And that is not the job of a technical committee, whose job is to draft. So there is some sort of unclear, murky waters there.
Okay. Now let's deal with the issue of the terms of reference. What do you make of the fact this committee is beginning its work without having published its terms of reference? We have gotten some news today, though, that those terms of reference have been handed over to the technical committee, but they began their work without having them in the first place. So what are your thoughts on that?
Well, my view has always been that this technical committee is a public body. And so really, ideally, the terms of reference should have been issued simultaneously as they were being announced. Because you can't, why are you appointing a committee without knowing what they're going to do? Surely you have drafted those terms of reference in advance so that those people know exactly what they're signing up for. So those things, because it's a public body, should have been published publicly, immediately, without people even asking for them. But I think really it's a case of too little, too late, because the process of how the technical committee has been appointed, as I've been mentioning, is flawed, because there's no legal framework that backs the appointment of this technical committee. And in my view, this flawed process is subject to judicial review, because the president, as I mentioned, does not have unlimited executive powers. They must be subject to a prescribed law, a prescribed legal framework under which this technical committee can work.
Okay. Well, Linda, I'd like to thank you so much for speaking to us this morning.
Thank you. It's been my pleasure.
All right, there we go. That is Miss Linda Kasonde. She's a respected constitutional and human rights lawyer. And she was speaking to us about what she thinks of that 25-person technical committee on drafting of the Constitution.